around people who are excited about their day, right? And today I'm very excited to welcome our friends, our colleagues from Melbourne Law School. And we are here to attend a very important discussion and lecture from Professor Foster about refugees and statelessness in Asia. So, welcome to Jentera, Bapak Ibu semuanya. And today, the students are mixed here and also in Zoom, because I think one of the very unique characteristics of Jentera is the diversity of the students. There are students who are already professionals, but also there are students who are fresh out of high school, and we mix everyone together to try a different way to get legal education. And I think to start with, I'm gonna invite Batita to come and say a few words, please. Let's give a round of applause.
So yeah, good morning, distinguished guests, colleague, and students, especially our biggest visitors. On behalf of Indonesia Jentera School of Law, it's my great honor to welcome you all today in the international chair. We are especially delighted to host Professor Michelle Foster, Dean of the Melbourne Law School, Professor Tim Lindsay, and also Professor Nadir Shah Hussain, who joined today. This really carry special meaning for us. In 2023, we signed MOU between Melbourne Law School and Jentera Law School under the leadership of Professor Dean Matthew Harding. That partnership was more than formal agreement; it was a commitment, collaboration, exchange, dialogue between our two institutions. And today's lecture, I think, is one of the tangible outcome of that collaboration. Although Pak Tim know a lot of us that already studied him as well, Melbourne Law School. Under your leadership, this partnership will grow even further, opening opportunity for joint research, student exchange, collaborative teaching, and other forms of academic cooperation. Our topic today, refugee and statelessness in Asia, is both urgent and deeply relevant. Asia is home to some of the world's largest refugee and stateless population. Their situation reflects not only the human consequences of conflict, persecution, and displacement, but also pressing questions about international law, human rights, international and regional cooperations. This is a subject that calls for rigorous scholarship, but also empathy and commitment to justice. We are fortunate to hear from you, Professor Foster, whose scholarship on refugee law and human rights has shaped the debates not only in Australia but also globally. And your insight will help us to think critically about policy choices that not only affect here in Indonesia as well, but also millions of lives around the world. We are also privileged to have Professor Tim Lindsay, who a well-known Indonesianist, whose work has long illuminated the complexities of Indonesia legal system and society. Many of our own lectures at Jentera have had the privilege of being your students, and we hope many more in the futures as well. And also to have Professor Nadisa Hussain, we hope that the collaboration and teaching between our two institutions will grow and foster along the cooperation. For our students and faculty at Jentera, today's lecture is invaluable opportunity to engage with leading global scholarship. So we hope that our networks with students and also with faculty can flourish to connect theory with practice and to strengthen our commitment to legal education that is responsive to the challenges of our time. I would like to thank Professor Foster, Professor Lindsay, and Professor Hussain for being with us and to express our hope that this event is the opening of many future exchanges between Jentera and Melbourne Law School. With that, let me hand over again to our beautiful moderator here, colleague Rivana, Mezaya, who will guide today's discussion. Thank you, and I wish you all fruit and inspiring lecture.
Thank you, Mbak. Okay, so I think the topic of today is very interesting. And aside from all the legal ramifications of being a stateless person, I think maybe many of us here can relate when we talk about a sense of belonging. Everybody here, every human must have sense of belonging. And imagine when you are a stateless person, then that very core feeling is also deprived from you, and many other rights and also opportunities are also deprived from you. And like Mbak Tita mentioned before, this is the region where the most stateless persons are, and we are so happy to have Professor Foster today. Let me introduce you a little bit. Professor Foster was appointed as Dean of Melbourne Law School in September 2024. So happy first anniversary for you. Yeah. And she, prior to this appointment, she was the director of the Peter McMullen Center on Statelessness at Melbourne Law School. She is the leading international authority on refugee law, human rights, and statelessness. She established the Peter McMullen Center on Statelessness in 2018 as the world's only university-based interdisciplinary center dedicated to studying and finding solutions to these global issues. She has written many journals and books on this topic. And I think without further ado, I would like to invite Professor Foster to the podium and give our lecture to the class, both online and offline. Uh,
Well, thank you so much. I really appreciate this opportunity to be here. Thank you, Ibu Rivana, for a lovely introduction. Ibu Tita, thank you so much as well. And of course, Pakari, thank you so much for hosting us today. As you said, we have a really important collaboration with this law school, and we very much hope to continue that collaboration. And this is really, for me at least, the first step in that journey. So I was saying to my on the way here that it's really lovely to have this opportunity not just to meet you all, but to speak about the research that I have been undertaking over the last few years. Especially as you mentioned, I've been for a year and haven't had a lot of opportunity to be thinking about statelessness and refugee law. So this was a real treat to be thinking about some of these issues. So I do have some slides. Oh, here we go. Very organised there. Now, as you would have seen from the topic, refugees and statelessness in Asia is an enormous topic. We do have some time to work today, but in thinking about how to prepare for this, I thought it would make sense to sort of narrow it a little bit by focusing a little bit more on statelessness. And that's because I hazard a guess that many of you are quite familiar with the concept of a refugee, and probably, even if it's not your area, you probably have a little bit of background and understanding of the issues. Whereas what I've found over the last sort of 10 years or so in working on statelessness is that it's a concept that is far less understood internationally and in our region and even in Australia. And so it's one that I thought I would spend a little bit of time on. But I know that we have plenty of time for questions. And so I look forward to exploring any issues that you may want to explore on refugees or otherwise. So in terms of what we're going to cover, I thought I would start with the basics. This is a law school. We love definitions, don't we, as lawyers? So always good to start with, what is the category of persons of concern here? So we'll start that. Then we'll think about statelessness in Asia. Again, I recognise this is Asia, it's a huge region. And so we're really just going to sort of touch on some of the highlights, but think about, as I say there, numbers, causes, consequences, and then touch on international law, because when we're looking at any human rights problem, and indeed statelessness is a very serious human rights problem, one of the questions is, well, how do we as an international community address this problem? What tools do we have? Are the mechanisms and tools sort of fit for purpose? And then to end on a more optimistic note, sort of what can we do in terms of resolving statelessness? You may be aware that the UN High Commissioner of Refugees had a 10-year plan to end statelessness by last year. And yet I'm still here talking about statelessness, so clearly didn't quite get there, but nonetheless there has been quite a lot of progress, and so we can think about that as well. So, as I say, starting with the definition. So we have the 1954 Convention on Stateless Persons, which, if you know anything about refugee law, you will know that the relevant international instrument for the protection of refugees is the 1951 Convention on the Protection of Refugees. And so if you think about that context, you'll understand that the 1954 Convention was almost a contemporaneous instrument, but it does deal with stateless persons separate from refugees. And the definition there is a stateless person is one who is not considered as a national by any state under the operation of its law. Now, I've got a question there. How is this different from a refugee? It's a bit of a sort of open question. I won't call on you. I know the Australian method of teaching is very Socratic, but I won't do that today. But if we pause for a moment, and I haven't put the definition of a refugee up there, but again, you probably have a bit of a sense, even if you haven't looked at the technical definition, you probably have an idea that a refugee is a person who is outside their country. So that's someone who's fled their country for the reason of persecution. So they've either fled or they're unable to return to their country because they have a well-founded fear of being persecuted for reasons of race, religion, political opinion, nationality, or membership of a particular social group. So if we think about that definition and then compare it to this really quite legalistic definition of stateless person. So we're not really told anything about the stateless person when we look at that definition. It's simply they're not considered as a national by any state under the operation of its law. So the first thing to observe is that it's a negative. You're not considered. So in fact, when a person establishes, if they're seeking to establish that they're stateless, they're trying to establish a negative proposition. So if you think for a moment about what that would entail, it's very difficult. Not considered as a national by any state. By any state? How many states are there in the United Nations? So again, start starting to think through how challenging it is for a person, if it was an individual determination, to establish that under the operation of its law. And again, there can be questions about how we interpret that. But I think the point is, in order to be a stateless person, you don't have to have left your country, whereas a refugee has left their country. They're outside their country of nationality. A stateless person may be outside their country, but they may be inside their country. And in fact, we know that most stateless people in the world are in situ. They have never left the region or the country that they think is their home. As Rivana talked about, that sense of belonging and inclusion. You know, we all belong somewhere. We're all born somewhere. Our family is from somewhere. But many people are regarded stateless in the country that they feel they belong to, but they will often be stateless for generations. And so that's one of the distinctions between a stateless person and a refugee. A stateless person may be a refugee, but many stateless people are not refugees. They've never left their country and they remain in their country of origin. Now, of course, having said that, there is very much a connection between statelessness and forced migration, as I've just said. So there can be an overlap between those categories. And this, of course, has been recognised, particularly more recently by the United Nations in the New York Declaration for Refugees and Migrants, which some of you will know that was the sort of precursor to the Global Compact on refugees. So you don't need to read it all there, but just to sort of say that there's that connection between refugees and statelessness. I should say that the UN High Commissioner for Refugees, as the name suggests, has primarily focused on refugees since its creation in 1950. It's always had the remit to protect stateless refugees, but it didn't get the authority under the UN to protect stateless people and reduce statelessness until the 90s. And so really the UN High Commissioner's work on statelessness is much newer compared to refugees. But it nonetheless is the key authority in the international system for the protection. So, if you were going to think about a particular category of concern, we start with the definition, but then of course we need to know, well, how many are there? How many stateless people are there? And what I find really interesting and what's really important to note about statelessness is that we simply do not really know how many stateless people there are in the world. The UN High Commissioner for Refugees has the numbers of refugees, the numbers of internally displaced persons, all the other categories of concern to the UNHCR are fairly well defined. They have a fairly good idea of the numbers. But when it comes to statelessness, the estimation is around, the official statistics are around 4 million, but the UNHCR says that somewhere between 4 million and 1 billion. I mean, just think about those numbers, because the World Bank estimates that about 1 billion people do not have registration or an identity. That doesn't mean they're all stateless, but it's somewhere between range. And that's an extraordinary concept. But actually, when you think about it, although initially that sounds extraordinary, when you take a step back and think about why that may be, it actually makes sense. Because if you're stateless, you're often legally invisible. You may not ever have had your birth registered. You know, you may not have national documentation. You're not considered even in Australia. We have serious issues, which I'll touch on in a moment, around estimating or understanding the numbers. And so we simply don't know. But having said all that, of course, I have got the numbers up there, and that's from the UNHCR. And it's recording the known populations of statelessness in our region. And you'll see here that blue are the non-displaced stateless people and the yellow are the stateless. So you can see, for example, Bangladesh. That's, of course, all the Rohingya refugees who have left Myanmar, or stateless refugees, and moved into Bangladesh. So we can see that, the UNHCR estimates that the majority of stateless people in the world are in our region. But again, recognising that the numbers are really an estimate because they are dependent on the states reporting to the UNHCR how many stateless people there are. And just to give you an example of the complexity, the UNHCR says that the global figure remains an undercount. They recognise that. For example, here they say, in terms of our region, 18 of 38 countries in the region did not report or reported zero stateless persons, even though we know that stateless people are everywhere. And to give you, and also often we're relying on things like media, NGO reports, academic publications, or sort of unofficial numbers. And just to give you an example of what I mean by this, to take an example from our region, Pakistan, just in one particular year, in 21, Pakistan reported 47 stateless people to the UNHCR, and that was stateless Rohingya refugees living in the country. In another context, a spokesperson for the Pakistani Foreign Office suggested that it could be as many as 400,000. So that's stateless people who'd moved to Pakistan. However, there are up to 3 million stateless people within Pakistan who are Bengali, who have never been given citizenship in Pakistan. So 47 versus 3.5 million. So that gives you that sense of why it's such an issue in terms of how can you properly identify the needs of people in need of protection if you don't actually know who they are or where they are. So actually understanding the data is an enormous challenge, and it remains one in this context. So what are the causes of statelessness? I mean, this is something that often it's a question that's often posed. It does seem extraordinary, the idea that even today people cannot have a nationality. Again, going back to the introduction, we feel that everyone has that right to belong and that right to be included. So how can it be that people can find themselves stateless? And as we say, in very significant numbers. Well, really, I think it's fair to say that at its heart, it's about discrimination. And that, of course, makes it so difficult to overcome. If we look at the various grounds of discrimination, gender discrimination has historically been a really important cause of statelessness. There has been progress on that. So we still have about 24 countries in the world that don't allow women to pass on their nationality on the same basis as men. And in fact, Indonesia was one of those countries that reformed its law in, I think it was about 2006. I might not be quite right about that. So that's a really good practice example, but we do have other countries in the region. Malaysia is undertaking reform at the moment, but we still have Nepal and Kiribati, for example. Many countries in the Middle East and the MENA region still have discriminatory nationality laws. So that's an important issue. Discrimination in terms of statelessness is a minority issue. So really racial and ethnic discrimination is often at the heart of statelessness. I talked about the Rohingya. I think that's probably the classic example in our region. In 1982, this citizenship law of Myanmar was amended to remove, so essentially there's a list of ethnic tribes that are entitled to citizenship, and the Rohingya was removed from that list. And that has led to ultimately, not just statelessness, but persecution and forced displacement as well. But there are, of course, other examples in our region. Migration and mobility is a really important issue. So migration, we've already that connect. But to give you an example, a colleague from the centre did a lot of work, Vietnamese, a lot of ethnic Vietnamese who then moved to Cambodia decades ago. So you can have that sort of combination of migration and ethnicity, but also mobility, including mobile populations. So colleagues on statelessness have done work on the Moken populations in Thailand and Malaysia as well. So that can be people who move around and who don't get registered and have access to that civil documentation. It can be issues in deficiencies in birth registration and documentation. You can imagine probably the easiest to address, because if it is an administrative issue, then that can be addressed through resources, through a sort of focus. Discrimination, as I said, is far more difficult to address. State succession, arbitrary deprivation of citizenship is again a really important issue. And to give you a really live example broadly in the region of Asia or India, we think about India as being part of this region. In the last couple of years, in the state of Assam, in the northeast of India, the National Register of Citizens has resulted in 2 million people being left off the register and therefore potentially stateless. So a few people are nodding, so it sounds like you have heard about this. And I think in a sort of fairly Orwellian move, those who are left off the register are permitted to go to foreigner tribunal to establish that they are citizens. But that's proving to be very difficult because often it's dependent on having documentation, which simply is non-existent. And the government of Assam has quite a lot of money building these enormous detention centres because the question is, well, what happens if you're found to be, left off the National Register of Citizens, if you're stateless? Well, sometimes there's back where they came from. That could have been, generations before, in this case, Bangladesh. That's not going to happen. So what happens? Well, people get detained, and that's what's happening in Assam. It's a very live question in our region. And then I guess an emerging challenge, and one that we haven't fully grappled with, is the issue of climate change and displacement. And I think that's fair to say that's an emerging issue in terms of thinking about it. We've been thinking about climate change for a long time, clearly. We've even been thinking about what it might mean for movement, for whether or not there's debate for a long time around the concept of climate refugees. Much more recent phenomenon where there's been consideration to what that means for statelessness, what that means for that sense of belonging. And it's not just about disappearing islands or disappearing countries. It's about people will move much earlier than the state will still exist, but their sort of connection with that state attenuates in terms of nationality. That's an issue that the Peter McMullen Centre on Statelessness has been working on as well. So they're all the causes. So let's then turn to, how does international law deal with statelessness? I already touched on the fact that there was a convention in 1954, but of course, as some of you will know, if you know about human rights, you will know that the birth of human rights, or at least modern human rights, can be dated back to the Universal Declaration of Human Rights. So 1948, post-World War II, the birth of the new United Nations system, and the Declaration of Human Rights set out really the template for how the new world order was going to be governed. Article 15, everyone has the right to a nationality. So that's fantastic. A big statement there. Everyone has a right to a nationality. So if that's the case, then why do we still have statements in the world? Well, I think part of the reason is, first of all, the UDHR, as you would know, is not binding. It was really sort of a template that was intended to then be translated into binding form. But the other point is that it's a right without a corresponding obligation. Because what does it mean to say, I've got a right to a nationality? So does that mean that everyone has a right to the nationality of the country in which they're born? Well, not really, because the international law's position on nationality is that it's fundamentally a right within the domain reserve of the states. So it's part of state property, and states cherish that right very much. Most states in the world would say, well, we have a right to determine the composition of our population. Understanding and sort of regulating citizenship is so it's a very difficult issue to say on one hand, one has the right to a nationality, but states get to determine their nationality laws. So, where's the balance there? What we do have is Article 2, which says no one shall be arbitrarily deprived of his nationality. So once you have a nationality, it's very difficult for states to take it away. But trying to argue for the right in the first place is more complicated. Come back to that in just a moment. But really, if you take nothing else from today, that's the core of the issue, really. So I mentioned other instruments. So that's 1948, the UDHR, but then it was translated in to two key treaties. So I've already mentioned the Convention on the Status of Persons, the 1954 Convention, which, as I said, really mirrors the Refugee Convention. Interestingly, the Refugee Convention on stateless persons, with refugees and stateless people being sort of subsets of the overall category of statelessness. But very early on in the drafting process, the drafters realised they were taking on way too much and decided to sort of separate out the two different issues. That history is relevant, though, because when you look at the two treaties, they're almost so they're very similar. So what that means is that people who are stateless really should have the same protection as refugees. But what we find in our region is that's simply not the case. And even Australia is a case in point there. So I won't go through too much detail there, but just to say that the 54 Convention provides the definition and then also sets out the rights to which stateless people are essentially, as I say, very similar to the Refugee Convention. So that's about protecting people who are. But of course, that was implemented. And then a few years later, the international community recognised, well, that's all well and good to have a treaty that protects stateless people, but let's prevent, isn't it better to prevent statelessness in the first place? So then we have the 1961 Convention on the Reduction of Statelessness. And Article 1 is the most important provision because it essentially says that if a person would otherwise be stateless, then they have the right to the citizenship of the country in which they're born. Now, everyone is born somewhere. So if that was implemented universally, we would end statelessness in a generation. However, we'll come to a moment to see that it's not very well, that there are not many countries that have signed on. It's not a widely ratified treaty, and even where it has been ratified, not every country, in fact, enforces that. But we'll come back to that in just a moment. Of course, I've mentioned the two key statelessness-specific treaties, but stateless people are also humans and therefore, of course, protected by all of the widespread human rights treaties. And I mentioned the UDHR, and I said that was not binding template. But of course, as many of you would know, that was then translated later into all, and I haven't listed them all, but we've got, all the usual ICCPR, CEDAW, CRC, so the International Covenant on Civil and Political Rights, the Convention on the Elimination of Discrimination Against, and the Convention on the Rights of the Child. And all of those treaties are relevant, particularly in the context of non-discrimination and equality in nationality laws. So again, while they don't necessarily say a state has an obligation to give nationality, they will say if you are providing nationality, which of course states do, you must in a non-discriminatory manner. And so particularly gender discrimination, race discrimination, these principles are really important. And so statelessness should not really be seen as just sort of this little separate issue over here that's governed by specific treaties, that in fact all of human rights bodies, and indeed in the last, I'd say 15 years, the human rights bodies generally through the Universal Periodic Review, but also through concluding observations and individual complaints, these bodies are becoming much more interested in statelessness, understanding how fundamental nationality is to the realisation of other rights, and therefore how that they should be in ensuring the non-discriminatory application of nationality laws. So in terms of thinking about, I suppose, the limitations of international law in our region, I've already mentioned the issue of ratification, and it is a serious issue. So you would know that there's issues in terms of the Refugee Convention not being widely ratified. I'd say more general human rights provisions, treaties are more commonly ratified. But when we come to statelessness, we have very low levels of ratification. So the 1954 Convention, they're the only 4 states in our region. And even then, so Australia, you would hope as one of the countries that's ratified the treaty that it would have a very good system of implementation. It has no system of implementation. So essentially, it is never properly implemented. Well, what I mean by that is that there's no, if you arrive in Australia and you say, I'm a stateless person, there's no visa category, there's no mechanism for determining statelessness. The only option is to try to find protection through, say, the refugee regime. And some people do. There are stateless people who are being persecuted for reasons of race, religion, etc. They can fall within the refugee definition. But there are many stateless people that cannot. And in Australia, just like in Assam, long-term indefinite immigration detention, because there's no visa category for them and there's no place to return them to, because being stateless means there's no country that has the obligation to take you back. So it's been one of the most critical human rights issues in Australia, and this is notwithstanding the fact that we've ratified the relevant treaty. Now, in the Peter McMullen Centre on Statelessness, we have been in the last few years undertaking quite a large study of statelessness in Australia, and we're getting close to producing a report that shows that even though the Australian government up until a few years ago said there were no stateless people in Australia, it's now said there's 8,000, but they didn't all just arrive in 1 year. So back to that reporting issue. But Australia has historically not really wanted to know about statelessness, and our report has shown that notwithstanding that, there are a lot of stateless people in the country, and we need to have a system. Because even just from good administration, even from the efficiency and administrative law perspective, we need a system. And then in terms of the 1961 convention, again, we only have a few states. But I've got sort of, this country that Indonesia hasn't ratified and yet actually does have a safeguard, which is essentially that use solely, that birthright citizenship for children born in Indonesian territory whose parents are of undetermined citizenship. So I guess what I'm saying there is that ratification of treaties is really important, but it's not necessarily the determinant, because we've got a country like Australia that has ratified but not implemented, and then you've got a country like Indonesia that hasn't ratified but is in fact implementing the key provision. So we always need to look, of course, as you would know, as good lawyers, not just at the ratification, but what it means in practice. So, I mean, I haven't got another slide on all the other treaties, but as I said before, it's not just these two treaties, it's all the widespread human rights treaties that have relevance here. And as I said, the international bodies have been much more active in recent years issues. So in terms of addressing statelessness in Asia, I mean, there's a lot of detail there, and I won't go into every single dot point. Challenges, and I mean, I'm not even sure these challenges particular to this region. I'd say just sort of generally, but there is a strong sense of sovereignty and non-interference, particularly when it comes to international law. Matters of nationality are seen as a prerogative of states. I think that's universal. I don't think that's just our region. As I said before, it makes addressing statelessness an extremely challenging task for that reason. And yeah, just the issues around identity, citizenship and statelessness are very sensitive, of course, and again, makes it very hard to address. Having said that, as I touched on before, there has been an enormous amount of work in the last, say, 15 years or so. And I think that the UN High Commissioner for Refugees really can take a lot of credit for that. As I said, it's probably hasn't done anywhere near as much as it should have, arguably, because as I said, the UNHCR has had the remit of stateless refugees since 1950, but it did nothing on statelessness until the 90s. Its remit was expanded through General Assembly resolutions to have the power to protect, or the sort of the remit to protect stateless people and to undertake work to encourage reduction on statelessness. And since that time, particularly since the launch of I Belong campaign, which was eliminated in 10 years, have seen a large increase in ratification of treaties. About 25 happened since the I Belong campaign. Extraordinary. These treaties they are increasingly willing to ratify, and not just ratify, but actually implement them. In the 2019 segment, many made pledges, including Indonesia, around better protecting, better identifying stateless people, better protecting them. So there has definitely been a lot of work at many other agencies. So SCAP, for example, have had another decade. So this idea of decade around registration systems, which has certainly made a big difference in terms of, as I said, the kind of the easier part of this work around better administration, better civil registration, birth registration is probably the most important component of statelessness. And there has been a lot of work done in that regard. The other thing that I think has been interesting is the connection between development and poverty and statelessness with the SDGs and UN development frameworks. So it's not just about seeing this as sort of a matter of individual rights, which I think is important, why we touched on the international framework, but also what it means for the country. Because to have documentation who don't have nationality is not great for the economy. So there is definitely a connection between poverty and statelessness, which has been understood. And, I think that means that we can sort of be addressing this through different mechanisms, not just the rights regime, but also development framework. And I think we can also see much more collaboration. So, we can see interstate through ASEAN. National level, there are lots of national state networks that have emerged in the last sort of few decades. And of course, regionally, there's been a very active regional civil society movement, Nationality for All, which you may have heard about. That's now sort of merged into Dignified Citizenship Coalition. And we've got other networks there as well. And then, of course, again, UNHCR providing technical support and capacity building. We've seen increased ratification, increased focus on statelessness, better rates of birth registration, seeing progress, but of course, we still have a way to go. But I thought I would just finish up by saying, we can see that the Nansen Award, which is the major award given by the UNHCR every year, so we can see here the recent award winner was an amazing woman from Nepal who's done a huge amount of work around trying to overcome the discriminatory citizenship laws in terms of gender in Nepal. And so I think it's not just the work that's being done, but sort of trying to bring attention and sort of highlighting this as an urgent human rights issue. But I thought I would just, in the last couple of minutes before we open for questions, just tell you a little bit more about what we are doing at the Peter McMullen Centre on Statelessness. Some mentioned in the introduction, establishing that about 7 years ago now. Really the rationale for introducing that centre, because we already had 20 research centres in Melbourne Law School. There are lots of centres around the world looking at refugees, so we need another. Well, I had quite a long academic career already in refugees, but I had sort of become interested in statelessness as an issue that, as I said, is connected with refugees, but also distinct. And we had the privilege of hosting a workshop in 2016 in Melbourne on statelessness in Asia. And it was through that process that I realised, my goodness, there's an enormous amount of work being undertaken on statelessness in our region, but also further afield. But there was no centre focused in a university. So there was no centre where we were able to sort of really clearly articulate this as a separate issue, particularly to the next generation of academic interested program, and to just generally undertake focused research. So I had this wonderful opportunity to set up a new research centre. And one of the things that we have done in the last few years is to set up through the Melbourne JD, the Stateless Legal. So it actually started as the Stateless Children Clinic, but we've now expanded it even a bit broader than that, clinic. And essentially this implementing Article 1 of the 1961 Convention, because I mentioned that Australia has ratified the 54 Convention and the 61, and I critiqued Australia a few minutes ago on the basis that we haven't implemented the 54 Convention really at all. But we have implemented Article 1 of the 1961 Convention, which you'll recall is that provision that says, if you would otherwise be stateless, then you get the citizenship of the country in which you are born. So that provision has been in our Citizenship Act for decades. But my wonderful Katie Robertson, who you can see just in that the middle person in the middle photo there, she is a graduate school, but for some time now, for over a decade. And through her work in providing legal representation to refugees, was coming across this issue where children were born in Australia, particularly to Rohingya, Palestinian families, other families who themselves were stateless. And she sort of almost by chance realised that there was this provision that would provide citizenship to the children. But Australia, essentially the system of legal aid is quite restricted. You get legal aid for certain types of work, and there was no legal aid for this work. She came to me. She's an amazing person, so we decided, yes, this is great. Let's bring her into the centre. And she had this great idea to really introduce a clinic that can be run by students. And it's really the perfect opportunity for students because the work itself is not overly complex. It's really filling out, very huge form. Great work because it means, the clients are often babies or young children. So the students are learning a lot about how to interview people, how to, take instructions. They fill out the forms and work with the Department of Home Affairs on those citizenship applications. And then the outcome is really amazing. It's life-changing. The work is really ending intergenerational statelessness. So many of these families will say, the parents will say, well, no one in our family in living memory has had citizenship. And they've come to Australia and now their kids have got it. And it really is the most incredibly rewarding work. So it's been really wonderful. It's really popular. We started with just 2 students and then every year have doubled. And in 25, we had 16 spots and we had 100 applications. And people are now writing, they're coming to the law school to do this work. So I think that's been really interesting for us to see that it is an issue that people care deeply about. When they learn something about it, they understand the importance of it and are really keen to be involved. So that's that, but probably more relevant to this audience is if you're interested at all, or you may know others. I know a lot of you are involved in law reform, so you're very connected across civil society. So if you know anyone who's interested in learning more about statelessness, and sorry, this is a bit like self-promotion, I don't really mean it to be like that. But it's just a really great course that we run. It's a 5-day intensive. So I'll leave a couple of not part of our month program. It's just a 5-day intensive online. So you can come here, and we do have scholarships, and because it's really just it's an opportunity to there's very it's not really taught in law school. It is a very specific area in court because we have people who are working in all sorts of diverse that suddenly just find themselves accidentally working on statelessness issues, and so they never had that chance to really understand the frameworks that I've outlined and the context. So you learn a lot from the instructors, but also from each other. So it is a really interesting course. And then the final thing I'll just mention, again, a little bit of self-promotion, sorry, is I've just recently published a book that I co-edited with two wonderful colleagues, Jacqueline Neo from the National University of Singapore and Christoph Sperfeld, who used to be with the Peter McMullen Centre. Christoph was with the centre and is now graduated into his own academic career. It's wonderful. So he's at Macquarie Law School. Yeah, so the three of us edited a book on statelessness in Asia, and I've just got a slide there. So if you want to learn more. Well, I've probably said enough. Thank you so much for listening, and really proud to take any questions, to hear whatever you have to say. So
Thank you so much, Professor Foster. Would you like to sit down? Yeah. So I guess we just had a very complete 101 course about statelessness, which is, I think, correct. It's a subject that maybe not as familiar as, let's say, refugee to us. But in recent years, obviously, with Rohingyas being in the region, the discourse is already there. The discussion about statelessness is already there. So thank you so much for giving us the 101 course, the very complete one. And congrats for the center and the clinic. I can imagine like this, the feeling of fulfillment of the students that are able to really help and make a difference in the children's life. Okay, so if you allow me, I'll just say some of the conclusions in Bahasa, so that maybe later if anybody wants to ask question in Bahasa also okay. I'll try to translate for you ya. Jadi tadi Profesor Foster banyak bicara mengenai statelessness, atau itu sebenarnya adalah orang-orang yang tidak bernegara, tak bernegara. Kenapa tak bernegara? Tadi banyak sebabnya. Ada bisa karena diskriminasi, karena dia minoritas, atau karena climate change, dan forced displacement atau terpaksa untuk dikeluarkan dari di mana dia tinggal dan lain-lain. Tapi yang menarik tadi Profesor Foster juga menunjukkan definisi legalnya saja dimulai dari negatif. Apa sih yang disebut statelessness? Mereka yang tidak memiliki warga negara apapun dari negara manapun. Jadi untuk membuktikan dia siapakah kamu, aku adalah yang tidak aja sudah berbeda kan. Bebannya dimulai dari negatif gitu. Kalau kita lihat dari kacamata definisi legal. Dan kemudian sebenarnya tidak ada nomornya ada berapa banyak sih statelessness? How many people are stateless? Actually, there's so many opinions ya. Tadi udah disebutkan kan, Pakistan report 47, ternyata katanya ada 3 juta. Tapi berarti ini jutaan bahkan sampai 1 miliar. Jadi ini bukan kelompok yang sedikit, banyak orang-orang yang mengalami statelessness. Dan ketika dia tidak berkewarganegaraan, maka kesempatan dia berpartisipasi di ekonomi juga terganggu. Makanya ada tadi isu development, poverty juga di sana. Dan menurut saya juga yang menarik lagi, walaupun hukum internasional ini sudah memberikan dasar di deklarasi HAM ya, Universal Declaration of Human Rights, mengenai bahwa semua orang itu berhak memiliki kewarganegaraan, tapi ternyata pada kenyataannya instrumen itu kan tidak mengikat. Yang mengikat konvensi, tapi ternyata konvensi tentang ini hanya sedikit yang menandatangani dan meratifikasi. Jadi negara-negara tadi disebutkan di region kita cuma 4 negara ya, dan Indonesia belum ratify juga ini. Dan yang menariknya lagi, sebenarnya ini isunya bersinggungan antara international law dan hukum domestik, kedaulatan. Citizenship itu kan diaturnya oleh hukum nasional ya. Kita punya hukum nasional sendiri, tapi ternyata ada hak di hukum internasional ya. Jadi itu kira-kira tadi yang dijelaskan oleh Profesor Foster dan juga pengalaman beliau meran klinik dan center di Melbourne Law School. So basically I just gave.
That was very impressive.
hopefully, hopefully it helps me as well to really understand and reflect back.
Really listening.
Of course. You're a good lecturer. Oh, she actually won a teaching award in 2013. So basically, we had a very good lecturer as well, aside from the dean as well here, right? Okay, maybe right now, if you're okay, I'm gonna open the floor for some questions. Kalau ada pertanyaan, silahkan. Yang di online juga kalau ada pertanyaan, silahkan. Oke, silahkan Mas yang di belakang bisa mulai. Boleh tolong dibantu. Perkenalkan diri dulu boleh ya?
Bismillah. Assalamualaikum warahmatullahi wabarakatuh. Good morning. Selamat pagi semuanya. Perkenalkan, nama saya Julianto Muhammad Ramadan Santoso. Saya seorang mahasiswa angkatan 11. Saya ingin bertanya, in English or Indonesian? Indonesia aja. Better. Sorry if I wrong spell word. If statelessness in Asia is influenced by politician, discrimination, and state sovereignty, how can the principle of non-interference in domestic affairs be balanced with international obligation to respect human rights? First, and second, the 1954, I think, and 1961 convention provide an international legal framework, but ratification in Asia is still limited. If many countries are not legal bound, can soft law intensive, such as the Global Compact on Refuse, the SDGs, or the Bailey process be effective in driving real change? That's all my question. Thank you.
Thank you so much for their wonderful. Excellent. The first point's really interesting, and you're asking really as a matter of principle, the sort of balance between non-interference and protection. And I think what I would say is that's at the heart of human rights law generally, because the introduction of human rights law really challenges that idea of non-interference, because human rights law is, if you think about international treaties that are about protecting human rights, they involve states taking on obligations about how they treat people within their own territory. So international law historically was much about sort of external matters, how states relate to each other, territorial boundaries, the law of the sea, all of those issues that were much more about state-to-state relations. But the advent of human rights law post-World War II really challenged in its nature the idea of non-interference. But on the other hand, it's states voluntarily taking on those obligations. So I suppose, because often the question is, well, how can you, as I said before, this balance of sovereignty and the rights of individuals? Well, states have exercised their sovereignty to ratify these treaties that burden them in terms of how they treat individuals in their territory. So I think in that way we can see, although it may seem like this sort of contradiction that can't be resolved, you'd say, well, we can resolve it by understanding that states have recognised that there is kind of a minimum set of requirements of legitimacy almost. To be a member of the UN, we take on these obligations. Now, leave aside the 54 and 61 convention, but the fact that most states, including Indonesia, have signed and ratified the ICCPR, which does provide non-discrimination and rights to equality, and the Human Rights Committee has said increasingly in recent years quite a bit about what that means for statelessness and for non-discriminatory nationality laws. I think we can see then that it does make sense that we can find a balance. So we say, yes, the determination of nationality laws does fall within state discretion, but that discretion is not untrammeled. It's not, it's not at large. The discretion is measured or tempered to the extent to which human rights law does provide some restrictions. So human rights law doesn't say states must have a certain type of nationality law, but it says if you're going to have a nationality law, which every state does, it must be non-discriminatory. So the best way to think about it is human rights law has chipped away at that broad state discretion. Does that make sense? So that's the principle. Is that what you were getting at? Sort of how do we balance this non-interference concept and the rights of the individual stateless person?
I don't know how to explain in bahasa in English.
Nggak apa-apa, Indonesia aja nggak apa-apa.
Menurut saya pribadi, saya tidak bisa menjawab itu dengan pasti karena di ini pun saya sebagai mahasiswa baru, jadi saya tidak tahu bagaimana hukum internasional itu berlaku dan bagaimana hukum di Indonesia itu berlaku untuk bisa nge-balancing untuk di Bali yang saya sebutkan tadi, entah penyelundupan atau apapun yang proses itu. Tapi menurut saya pribadi, kalau misalkan konferensi itu akhirnya tetap tidak mereka terreplikasi ya, sorry kalau nggak salah katanya, itu berarti kan masalah ini tidak akan pernah balik lagi seperti 1954 itu kan dia tidak menjelaskan bagaimana mencegah itu kembali itu terjadi, dan di 1961 walaupun sudah diberikan caranya tapi tidak dilaksanakan, menurut saya itu menjadi polemik yang dimana setiap negara kan punya otoritas masing-masing. Hukum nasional itu tidak mengikat semua negara. Bagi saya di situ.
So he's explaining that he's just starting to study the balance between international law and domestic law. So, but in his opinion, actually, if it's not binding, if something is not binding, then how do you balance the maybe internal dynamics with the international obligations? Because every country would have national dynamics as well. And he also mentioned, like, for example, the two conventions, very little ratification. Then how do you usually you see the balance being played out?
So I think the binding one's interesting because if a state ratifies a treaty, then they are bound as a matter of international law to that treaty. But then the question is it binding as a matter of national law? And that plays out, say, in Australia all the time because we have ratified pretty much every major human rights treaty. But because we have a dualist system, those treaties aren't binding as a matter of national law unless the parliament legislates those treaties. There are, however, other ways in which they're relevant. So, and I can't speak for the Indonesian domestic system, but in Australia, it can be relevant as a matter of interpretation. So there's a principle of interpretation that if there's ambiguity in a statute, then you would take the interpretation or adopt the interpretation that's consistent with international law. So it can kind of come in that way. But it can also be really important in terms of, I suppose, shaming the country. So if the individuals go to the Human Rights Committee and argue that Australia is in violation of a particular provision, and the Human Rights Committee says, yes, you are in violation. Sometimes, not always, but sometimes that can be very effective as a tool of advocacy. So it's not binding, but it's that sort of idea that this is, we regard ourselves in Australia as a civilised member of the international community, that we uphold standards. And if we can make that case, then, as I say, I don't want to be exaggerating this situation because we've had probably 40 occasions on which the Human Rights Committee has found that our system of indefinite detention is unlawful, and yet the government has not changed it. But there have been other examples around the equality rights of homosexual people where the Human Rights Committee finding back in the 90s made a huge difference. So the Commonwealth was able to use that to legislate, and it was a matter of sort of the government having been shamed. So I think it is complex. I'm not sure if it's in Indonesia a monist system or dual system with international law. Okay, so yeah, so it is complex. The 54 and 61, it is, as you say, it is an issue because even though we've seen quite a large number of ratifications in the last 10 years since the UNHCR started its campaign, and as I said, about 25% of the ratifications have come just in that period, we're still below 100 ratifications for both treaties. So I think for the 61, I might be getting them mixed up, but one's almost half the number of UN members and the other one's a bit below that. I guess you'd say, well, the fact that countries are slowly ratifying means that there's still more work to be done. So we have to continue that work. But I think what is promising is, as I mentioned before, this push to encouraging other more sort of mainstream mechanisms like the UPR through the treaty bodies to be thinking about nationality and statelessness. And then the other question you raised was around soft law, which I think is really important. And the Global Compact, again, for those of you who know about refugees, you'll know that the Refugee Convention, where to start? That would be a whole new lecture. But let me just say that Refugee Convention, say that one of the main, probably any sort of responsibility sharing. So it's mentioned in the preamble, but there is nothing in the Refugee Convention itself at all about responsibility sharing or international cooperation. We have resettlement schemes like Australia country, but that's not mentioned. So the global, in that context, the Global Compact is really seeks line a sort of method by which we may be able to engage in international cooperation. And that's, I think, the most critical issue in our region. It is the most critical issue. It's an issue that the Australian government has been talking about for decades. When it tries to push refugees away, it says, "Oh, we need a regional solution," and yet hasn't really done the work that's required. So I think that the Global Compact does hold promise, but it's still early days, and we have to see how it plays out. Of course, it's not binding, but almost every state, I'm not even sure what the right sort of adopted it, whatever that means. It's not, haven't ratified it, it's sort of treaty. But it has got widespread support. And so I think from the context, it doesn't say a lot about statelessness. I mean, it's really the development goal. Not so much entity to soft law, all those sort of alternative ways of thinking about the problem are really important. But it is hard, as you say, because it's so political, because it's so anchored in discrimination. It's not easy. But at least when but definition, it's very technical. So I think for a long time,
Professor, can we use any customary international law to strengthen the binding power of the statelessness regulation?
I think that's a wonderful question. And it's interesting, I don't know if you noticed, mention that has attained that status. That's great. But stateless people. Into of the UDHR, the right not to be arbitrary. Authority. I think
Okay, thank you, Julianto, for starting the question. Should we go to the online first? Maybe one question, yeah. Hello, the 51% attending online. Let me read it, the questions for you, or if you want to come here as well. Yeah. This first. Yeah, how should the international community respond to the situations where refugees are hosted without any clarity on the duration of their stay or on long-term solutions, as seen in the case of Rohingya in Indonesia?
Look, I mean, I think that's a great question, and I probably don't have all the solutions. Otherwise, we wouldn't have the problems we have. But I think, in some ways that does connect back to the question or the statement I made earlier about the Global Compact, because really the Global Compact is trying to address this ice issue. So the Refugee Convention, I think, does assume in some ways it of refugee status. So it sort of envisages that people may cease to be refugees because the situation of refugeehood is temporary, and they might return after a certain number of years. Whether or not that was ever the case, I'm not sure, but it's certainly not the case today. If we think about all the protracted or major refugee situations globally, they're all very protracted. And we do have this problem of people sort of being in kind of a temporary situation, whether it's, in Bangladesh, Rohingya refugees in Bangladesh, in Cox's Bazar, or whether it's in Indonesia where it's probably not so much sort of a particular place. Refugees are living in urban communities as well, but don't necessarily have a long-term solution because, of course, here in Indonesia, without ratification of the Refugee Convention, yes, the UNHCR has presence. The UNHCR does make determinations as to whether people do meet the criteria, but that doesn't necessarily translate into a sort of a durable stay here in Indonesia. So there is this issue. So yes, the Global Compact is attempting to sort of recognize that and to recognise that the responsibility of refugees is not shared equally, that about 85% of the world's refugees are currently in states that are sort of low to middle income. So even though the Western or sort of developed higher income states are the ones that have imposed all sorts of barriers and engage in practices that are really about reducing their responsibility and under pretense that they, states like Australia would say, oh, we have so many refugees, but of course the numbers that come to Australia are minuscule. So we do have this huge imbalance where we've got countries that are the wealthier countries having a lower proportion of the responsibility, and on the other hand, countries like Indonesia having more refugees. So the Global Compact is designed to rebalance that. But again, it's a soft instrument. It's taking time to implement. So it is a real challenge. And yes, I don't have all the solutions, but I do think, the resettlement scheme, I suppose if you think about it again from our region, Australia's resettlement scheme is exactly designed to rebalance that disproportionality because it's about saying it's not about, so we resettlement scheme is one where the Australian government asks the UNHCR where are the populations most in need. So it's not about how long people have been waiting on some list. It's every year looking at, well, who's most in need, where can we take refugees and bring them to Australia on a permanent pathway. Yeah. And they're often refugees who have been assessed by the UNHCR in a country like, well, probably not Indonesia, but other countries that are non-signatory states, where the UNHCR has a presence, has made the determination. So we don't need to do that. We just say, well, let's take those refugees. Unfortunately, refugees from Indonesia through that scheme over the years. And I think that's partly, well, not partly, it's political. I think there's a concern that if we do that, that will attract more refugees to come to Indonesia. I'm not sure that's right, but I think that would be a really cool way in which Australia could, in fact, step up and assist with this problem in the region.
I think that really relates to this question from Adil, like what kind of resources available for civil society actors to try and engage with the potentially complex political situation assisting refugees in Indonesia. Like, for example, maybe Indonesia has argued that it doesn't have responsibility to give care to refugees who actually want to come to Australia.
I mean, there's a lot in that question, I suppose. There's quite a few issues. It's really great. I mean, I think, and that is the difficulty, isn't it? Because Indonesia, I think I'm right. I mean, I'm very respectful of you, have much greater about what the situation is here, but I understand that is the issue in Indonesia is that Indonesia doesn't see itself as a destination country. It sees itself as a transit country.
Transit country.
Yeah,
okay.
and so not having ratified the convention and saying, well, we really shouldn't have to take on what is a responsibility for Australia. But I guess one response to that for generations from and perhaps again going back to that sort of development argument, even if we leave aside, because the individual rights argument's often not very persuasive to politicians, but maybe more of an argument, funnily enough. But if the argument could be that it would be better for the economy if refugees could work, and if they are working legally, they're paying, contributing in lots of other ways. Because actually having sort of a sector that's being left in limbo without rights isn't necessarily good overall, forgetting about whether or not it's good for the individual. But in terms of, what support can be given to civil society, I mean, it is difficult. I know that civil society actors here in Indonesia are, in fact, stepping in often, providing that support, just like in Australia, that happens as well. But of course, it's much, obvious here. So, I'm not really sure what the answer is other than to say, I mentioned that there are regional networks, particularly in statelessness, but in refugees, there's the APRIN, the Asia Pacific Refugee Rights Network. There are more and more sort of civil society actors who are seeking to work across the regions. Now, I'm not sure that those networks are able to provide material support, as in here's money to help you do the work, but certainly not just moral support, but sort of technical support. So I think that's really important. And then just, generally, I guess maybe one thing to do is to provide the research so that you have evidence-based arguments. And that's the point I'm making about this get off the ground at the centre on statelessness, around the link between poverty and statelessness. We hope that would actually be quite persuasive to governments as to reform. So that's something that, maybe Australian universities and research centres would help and engage with NGOs here in Indonesia to understand what would be helpful, and whether it's helping to write a submission to a university or whether it's actually about undertaking research that could lead to arguments for policy reform.
Okay. Maybe I go back to the offline audience here. Okay, silakan for the next question.
Hello, good morning, Professor. I'm Ido. I'm the student of the Indonesia Jentera Law School. I think mine is a cross-cutting with the Juliantos and the online question, but I want to make it more specific. How does a prioritized country make decisions regarding the acceptance of the refugees when its citizens oppose it? It's related to Indonesia, the Indonesia netizen actually fighting with the UNHCR about the Rohingyas and Acehnes. And what about your opinion? And the second is, Indonesia is not ratified the Geneva Convention 1955, but I think the children of the statelessness or refugees in Indonesia, it's apa ya bahasanya? Apakah bisa apa can the can have the protection about the other convention, especially Convention of the Right of the Child 1990. I think it's prioritize the children of the refugees. Thank you. This.
Great, thank you so much. So just so I understand it, the first question about how does a state conflict with and then you have refugees coming in, and how do you sort of balance those obligations? Is that the question? Yeah. The heart of the challenge, particularly, the heart of the challenge in Australia, even though we're a very wealthy country, certainly has the resources needed to provide that protection to refugees. But of course, it's much more real in a country like Indonesia, and I think it's a really valid concern. And that's why we have to have a regional or an international solution, because that, as I said before, this problem that we used to have 70% of the world's refugees were in lower income countries, and now it's 85%. Over the course of my teaching in refugee law over 15 years, we've gone having the we do as an international community need to recognise that deal need. And I think saying, oh, we're going to send refugees to, that's not a, that's saying, and you may have read that we are again going to send more refugees now because I don't know how much detail we go into, but that we can't detain people indefinitely, we need to release them into the Australian community. And so now the government's saying, okay, well, we'll release them into the community and then back to Nauru. That is not a regional solution. That is not a responsibility sharing approach. It's regional measures and regional solutions, but it's not actually a regional solution. So I think, yeah, it's just an issue we have to keep working through. And then the other issue around children, as I said, there is a safeguard in Indonesian law that provides nationality for children who are born otherwise stateless. But I really don't know, and I'd love to know if anyone has knowledge of this, how it plays out in practice. So I don't know what that means. If, a child, for example, is given that right, but then the parents are still not recognised at all. What that means for the family as a whole. Does it actually mean anything in practice? I actually just don't know. So that would be really interesting to find out a bit more about that. Because again, it's one thing to have the provision, like saying in Australia, it's provision in our law for decades. Complicated. Wonderful. Yes, absolutely. Yes, we have quite a few PhD students in the centre doing all sorts of wonderful research, but we don't have anyone working on Indonesia at the moment. We've got people working on Thai stateless people. In person just finished a PhD on Nepal. A lot of our PhD students.
Yeah, so Ido, it's an opportunity for you to learn even more. And I think your answer about the regional cooperation and how the prioritization, quote unquote, cannot be shared alone. I think it also answers some of the questions online here on that particular matter. So I think we have opportunity to only one more question. So if anybody has any more question, or I go online. Oke, maybe boleh di scroll bawah, Mas, untuk one last question-nya. Tadi udah dijawab, Pak, yang regional cooperation kayak. Iya, yang ini. Di bawah, boleh ke bawah? Stop dulu, stop. Oke. Maybe yang ini ya, yang atas ya. Ini ya. Oh, ini information lagi ya. Oke. That's very good. Bawah lagi, sorry. Tadi itu di bawah. Atas, di atas, maaf. Ya. Maybe this one ya. Many countries deliberately ignore or do not ratify the convention due to political dynamics and economic condition. You mentioned that some of the consequences that will be faced is basically the shaming part, right? Like if we are saying we are part of a civilized society, then we should be able to adhere to this basic standard of human rights. But maybe I want to follow up this question with in our region specifically, where actually we have ASEAN plus Australia in the talks. Do you think there's a possibility of ASEAN having a legal framework plus the partners like ASEAN plus Australia, ASEAN plus Japan, the regular partner to actually tackle this legal framework regionally?
I think that's a great question, and actually a sort of a nice way to end in a way, because I did sort of intend to cover that in my presentation but ran out of time. I think what's important is we talked about international law, but it's the regional human rights conventions which are often far more powerful, particularly in the context of refugees. So if we look, for example, at the European Convention on Human Rights, that has done far more for refugee protection, not just in Europe, but globally, in fact, than the international conventions. And that's because, I mean, the developments in Europe often then feed into developments globally. Just to give you a quick snapshot or a quick example of that, I've talked about Australia trying to send refugees off, or not trying, but it has, of course, sent refugees to other countries in the region. The UK government is also trying to do that. It's been inspired by Australia to push boats back, etc. Well, it's having a much harder time because of the European Convention on Human Rights. So I think regional treaties are really powerful. And when you look at refugee protection, our region is it's the big gap. As you say, we've got the ASEAN Declaration on Human Rights, but we don't have a binding regional human rights framework. And I think that would hold enormous promise. The difficulty at the moment is, for example, the Bali process, and someone mentioned that earlier. That is an example of regional cooperation, but it's very much focused on smuggling. It's very deterrent focused. It's not particularly sort of pro-human rights. So I think there is a lot of promise. There's a lot of potential there, but again, whether the political will is there, it remains to be seen.
Okay, maybe we give round of applause to Professor Foster. Thank you so much for your sharing today. I think maybe before today, we only heard statelessness maybe like once or twice. But today alone, I think we all become very much more aware and the complexities of first the legal framework, both internationally and nationally. And second, also the complexity of the real situation that these people are facing and still to be answered and to be further research is how we can solve more and more and to be nearer to the promise of the Universal Declaration of Human Rights that Professor Foster has mentioned. Thank you, everybody, for your participation. Again, once more, round of applause for Professor Foster here. And if I can invite you to the front here, because there is going to be some souvenirs from Jentera. Maybe I'll invite Mbak Tita to give the souvenirs. Thank you. Yeah. And maybe there are also souvenirs for Professor Tim and Professor Nadir as well. Maybe not Irwan Tita ya Pak. Maybe Pak Arif and Bang Gama, please. Welcome Pak, please. And if I can trouble you to just turn around so we can take a photo with all the attendants. Just turn around here. Ayo berdiri semuanya boleh kita ikut foto. Mas, kalau di foto dari depan. Nah ini atur sendiri ya kalau mau kelihatan gimana ya. Atur sendiri belakang dan semuanya. Oke. Thank you semuanya. Again, thank you for the online and offline attendance. If you are interested on this issue, jangan lupa ikut kelas hukum internasional sama Mbak Reni. Wajib. Dan harus nanya-nanya yang banyak ya. Terima kasih semuanya. Saya tutup. Assalamualaikum warahmatullahi wabarakatuh.